Under the uniform for disposal item number one.
Oh, that matter. Whether the pleadings which I have decided to file is complete.
Pleadings are already
No,
complete.
with regard to the subsequent inspection report which was
My lord, that I have handed over to my lord.
complete.
My lord, I have handed over. My lord may remember that a particular.
No, the inspection report which I directed to respond to that report, whether that is complete. You are appearing for the petitioner. Who is
that
appearing
my
for the
learned friend can submit, my lord. That is there. Number one. One more thing I have to submit, my lord. Your lordship will appreciate, my lord. The dispute which is sought to be raised is a factual dispute. Whether my lord will at all enter into that or not.
Very well, that way I will hear you. But where is Mr. Chatterjee?
He should be on the way, man. And just pass it on. He'll be.
Well, not today. Not today. Next Thursday. I will hear you. Obviously, you are representing the corporation. Not today. Since I have directed whether the copy of this, I have directed to respond to the inspection report.
Exception to the inspection.
Yes, whether that response has been filed, whether the copy has been supplied to you. You are representing the private respondent. Whether the copy has been supplied to you, whether the exception to the inspection report has been prepared, confirmed, copy has been given to you.
Yes, bro.
Come back on next Thursday, it will retain its own position.
No. দেখুন please. Four. Yes, my lord. One exception report filed by.
You are appealing for the private respondent. Whether you want to file any reply to this exception? Yes. You are Junior Romeo Narayan Mukherjee.
He is son of Mr. Job.
Yes, that I know.
Interesting.
Next matter. Not today. No order. Sorry.
I'm for the municipality, my lord.
Yes.
I'm for the municipality, my lord.
You are for the petitioner?
I am for the petitioner, my lord. This is my affidavit of service.
No.
Municipality.
Now the demolition order has been passed by the municipality.
Yes,
Where is the demolition order?
that is at page 34.
Yes.
34
Page 34.
and page 40, my lord. Proceeding under page 40.
Page 34 is the decision of
Board of Councillors.
just a
And
minute, person to go to. Now the service upon the private respondent is complete.
yes,
You are for the petitioner.
I am for the.
My lord,
Just a minute. You are for the municipality.
municipality, my lord.
Just a minute. Yes, what do you want to
My lord,
submit?
this writ petition, my lord, against the, my lord, implementation of the order passed by the municipality, my lord.
Yes,
We have already, my lord, demolished the illegal and other construction, my lord.
in terms of the demolition order,
My lord. This is the,
report,
yeah, this is the notice, my lord, which we have been served upon the,
just a minute. Demolition program. No, this document shows that you decided to demolish on
Yes, sir.
22nd of January 2020.
this is the communication, my lord. We have communicated the learned lawyer, the petitioner, my lord, to state that we have already demolished the.
Learned lawyer of the petitioner in writ petition number 8194.
Yes, sir. Yes, sir.
Oh, right.
Yes,
No, my lord. What I am wrote a letter that demolition has not yet been done. And that's why he has written that the and demolished and damaged the interior. The allegation made by you is not correct. It is surprising to note that the exhibit was held, but your client has not raised any objection, then which is raised after a lapse of 10 months, which sufficiently proves that the allegation is baseless. It is true that partly demolished, but not fully demolished.
but how your writ petition is maintainable? Because you have filed this writ petition on 18 March 2019 for implementation of the order of demolition. According to the municipality, demolition took place on 22nd January 2020. So therefore, this issue cannot be gone into in this writ petition. Let this writ petition be disposed of, granting
With
you
a
leave to
direction
file
to file
afresh,
afresh.
if the demolition is made not full.
Yeah.
Because you
I
have
understood.
filed this petition on,
Yes.
on 18 March 2019. According to the
For implementation
municipality,
of the order.
demolition took place on 22nd January 2020. So after filing of this writ petition, issue. Writ petition is filed for implementation of the order dated 29 September 2018. Passed by the chairman now. Implementation of the order of the concerned authority of Bardwan municipality, which was taken based on the decision of the board of councillors of the said municipality. তবে একটু মনোযোগ দিয়ে করো, বড্ড ভুল হচ্ছে। said municipality. Stop. Next paragraph. Today, matter is heard in presence of the learned advocates representing the petitioner and Bardwan municipality. However, in spite of service of notice upon the other respondents, those respondents are not represented today. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. It has been submitted by the learned advocate representing the petitioner, representing the municipality, that pursuant to the decision of the municipality dated 29 September 2018, a notice was issued vide memo dated 7 January 2020 by the subdivisional officer Sodor within bracket North and administrator, Bardwan municipality, addressed to the superintendent of police, Purbo Bardwan, wherefrom it appears that on 22nd January 2020, date was fixed for demolition of unauthorized construction from 10 AM and the police authority was requested to provide adequate police force to facilitate such demolition program. Subsequent thereto, another notice was issued vide memo dated 2nd December 2020 to the learned advocate for the petitioner. Timir Boron Shah, you are Timir Boron,
Yes.
learned advocate for the petitioner, intimating him that demolition was made on 22nd January 2020. Both the memoranda dated 7 January 2020 and 2nd December 2020 are placed before this court and taken on record. Next paragraph. It has been submitted by the learned advocate representing the petitioner that though demolition drive was taken on 22nd January 2020, but it was a part demolition. Therefore, decision of the demolition taken by the municipality on 29 September 2018 is not fully complied with. Next paragraph. However, considering the grievance which is made today on behalf of the petitioner cannot be delved into in this writ petition, since the writ petition pertains to implementation of the order of demolition dated 29 September 2018, which was filed prior to the demolition work made by the municipality on 22nd January 2020. Stop. If petitioner has grievance after the demolition work which was undertaken by the municipality on 22nd January 2020, necessary steps are required to be taken in accordance with law from the end of the petitioner, making appropriate statements in the necessary steps are required to be taken. Okay? No, end of the petitioner. Stop. Next paragraph. In view of aforesaid, the writ petition stands disposed of, thereby granting leave to the petitioner to take steps accordingly, if so advised. There shall be no orders to cost urgent Xerox certificate copy. Next,
Item number 3.
at the time of call, no one appears for the petitioner and no accommodation is paid for. However, Kolkata Municipal Corporation is represented by learned advocates. Next paragraph. Same situation prevailed on 8 February 2024. It appears petitioner has lost interest. Writ petition stands dismissed. Intimate of stands vacated. Urgent Xerox certificate copy. Next.
Item number 4.
I'm for the state lordship.
My lord, Mr. Imtiaz Ahmad is appearing on behalf of the petitioner. He is currently on his legs before the Honorable High Court of Punjab and Haryana. So I will be praying for not today.
You are for the state.
State lordship.
What is the matter about? What is the matter about?
My lord, I do not.
Are you junior to Mr. Ahmed?
Yes, my
Mrs.
lord.
Ahmed?
Yes, my lord.
Then why you have not read the brief? This is the second date. It was taken up on 8 February 2024.
My lord,
You
we
are a
have-
junior member of the bar. You should take these opportunities to open your mouth before the court.
My lord, actually,
Yes.
he has left and we have no information about when he was returning. So we could not get the brief from his chamber, my lord. And we have missed the date on the early
So-
occasion.
At the time of call, accommodation has been paid for on behalf of the petitioner. Since the learned advocate representing the petitioner, he is not in court,
No, my lord.
is not in town. Stop. However, state respondents are represented by learned advocate. Next paragraph. In order to grant one more opportunity to the learned advocate for the petitioner, hearing of this matter stands adjourned till Thursday next. When it will appear till Thursday next, comma. See 7th March 2024, when it will appear another same hearing.
Grateful. Deeply overlooked, my lord.
Dada. State. Grateful, my lord. Provide.
Item number 5.
I am for the petition. Upon the date of the petitioner.
I am for the state respondents, my lord.
Substitution application has been filed for substituting the legal heirs of the petitioner's lordship.
When died?
Lordship, the petitioner died on 6th August 2020.
And you have filed application on 1st
Lordship, after
July
after,
2022.
Lordship, after
You
obtaining
have
the
to file an
liberty from,
application for setting aside abatement.
Lordship, after obtaining the liberty from the Honorable Court, Lordship, at page 14, Lordship, on 7th July 2022, Lordship, by Honorable Justice Amrita Sinha, I have filed this
Yes,
application, Lordship. Immediately I have filed this application, Lordship. For
but you have to
substituting-
file an application for setting aside abatement. 90 days, 60 days. The petitioner died on 6th August 2020.
Yes,
You have
Lordship.
filed application on 13 July 2022.
Yes, Lordship.
What is the period of limitation?
60 days.
90 days and 60 days.
Yes, Lordship.
So therefore,
On the basis of the liberty given by the Honorable Court, Lordship, may I?
no, liberty might have given you to take steps. That does not mean that you are not required to follow the procedure. Have you prayed for condonation of delay?
Lordship,
No.
for allowing the
File an
substituting-
appropriate application.
Lordship, give me leave to file the.
What leave is required? No leave is required.
Lordship,
Or that a leave is required.
Lordship, and next part, Lordship, the Honorable Court was also pleased to direct the DLB to supply the status report also, Lordship, on the.
Nothing can be passed unless and until substitution is made.
Yes.
Today petitioner is
Then
no more in this world.
Yes,
No
Lordship.
order can be passed.
Yes, Lordship.
Esho.
Lordship, then.
In spite of specific direction, did not submit the death certificate and other documents.
Death certificate I have already annexed at page 9.
Substitution the writ petition along with the substitution application being can 1 of 2022 is taken up for consideration. Since the substitution application has been made available by the department in terms of the previous order dated 8 February 2024 passed by this court. Next paragraph. However, on next paragraph, state respondents are represented by learned advocate. Next paragraph. However, on perusal of the substitution application, it appears that the sole petitioner,
Sri Ashwini Kumar Das.
just a minute,
2020.
that the sole petitioner died on 6th
Please,
August 2020, whereas substitution application has been instituted on 13th July 2022. Stop. The learned advocate for the petitioner prays for accommodation to take necessary steps. Next paragraph. Hearing of the substitution application stands adjourned for 2 weeks. Next paragraph. List the matter under the heading application.
Hello.
On 22nd March 2024. Next,
Get
take out an application, appropriate application.
By mistake, I have not mentioned for condoning.
Next
the-
matter.
Item number 6.
I'm for the petitioner, my lord. The petitioner,
My lord, item number 6 and 7 are analogous matters. I'm on behalf of the municipality.
6 and 7
Yes, my lord.
and other analogous matters.
No, these two are
These are the
analogous matters.
analogous
Yes,
matters.
yes, same.
Which municipality you are?
I'm
representing?
Kamarhati municipality.
my lord, the petitioner is the wife of deceased employee of Kamarhati municipality. He applied for the family pension, my lord. These two judgments, one is passed by your lordship and another is other bench, my lord. Is
Take it out. So you are seeking pension.
yes, my lord.
When your husband died?
My lord, on 2011, my lord.
2011.
Initially, the petitioner is appointed as a peon in the Kamarhati municipality.
Expired in the year 19 September 2014.
Oh, my lord, in 2014. In,
You are not ready with the matter.
yes, my lord, I am
Then-
ready.
Why you are stating wrong date of date?
My lord,
date.
the next
Yes,
matter
what is the date of date?
Date of date September 19, 2014.
Whether there was a Mr. Ghosh, you are representing state.
Uh,
Whereas whether there is a direction for filing affidavits. No direction.
Petitioner's prayer is to the municipality to release the area pension as well as the gratuity amount. Now, we have to take instruction whether the concerned.
You are representing the director of local bodies.
Yes,
So why pension is not being paid?
whether that.
Yes, I will hear you.
that the deceased employee was the active staff or not, matlab that matlab the form I have to ascertain from the DLB.
Nitai Chandra Singh's order passed by this court in case of Navadvip municipality. Court is passing or your department has also cleared the cases of similarly circumstanced employees.
In respect of this petitioner, matlab I have no matlab instruction regarding his status.
Yes.
My lord, in these two matters, we have sent the pension book to the DLP, but they are not releasing the pension book to us.
Why?
And that is best known to them, my lord.
You are
My lord, the
also
initial, my lord,
the
the,
municipality.
yes,
You
my
must
lord.
have been informed by the.
I have informed every time I have sending.
Must have been informed. You have been informed by the DLV.
No, my
DLV must have informed.
no, they are not. They are not informing anything, my lord. My lord, we have actually what happened. The initial approval is there, but the post facto approval is not there, my lord. And that post facto approval order we are not getting from the DLP. They are not releasing the service book.
Order I have passed.
Yes,
and
my lord.
Based on this,
Yes,
several
my lord.
orders have been passed by this
Yes,
court
my
in
lord.
all matters.
Yes.
In all matters, the petitioner has petitioners have received pension.
Yes, my lord. In those matter of
Similar case, post facto approval.
Yes, my lord.
How long? Ask him how long he is working.
21 years, my lord.
Yes. See the situation. And now after retirement, department is saying, no, you don't have the approval. Who will believe it?
My lord, with our best efforts, we have given them the provisional pension, my lord.
Requesting my land guidance, give the date when the document has been forwarded to the DLB so that I can take necessary instructions.
All the
My lord,
documents are
the
there.
service is regularized.
সেটা জানি না।
My lord, the service is regularized on 8
My lord,
March.
there were
1990.
prior orders for directing the DLB to release the service book and to take necessary steps, my lord. Your lordship's orders, Gobindo Ghosh and other matters.
These three matters all are similar kind of matter, my lord.
আচ্ছা, এটা
Either one the prospectus was already accorded in this case also.
My lord, once come, kindly
Yeah.
once.
The prospectus approval, whether it was at all accorded already or that has to be
After utilizing service of the petitioner for 21 years,
Yes.
it's a fun. What steps your department has taken when the petitioner was serving? Just a minute. I have also passed in the case of Purulia municipality.
My lord, in some of our matters also, against the Kamarhati municipality you have passed, but those matters are there, they are also not releasing, my lord.
And already your department has issued a memo.
Yes, my lord, this one. No, I mean, এই তো order God. Gazetted order
6th February 2023.
Yes, my lord.
Yes. Show him.
Para one দেখুন। Petitioner is appointed in the vacant post, my lord. Page number 23 of service book of my application, my lord. The driver.
ना हो गया, मैटर हो गया। हाँ दादा, अनन्ना, अनन्ना बंदोपाध्याय अंदर में गया है। ओ बाबा, छोड़ दीजिए, छोड़ दीजिए, कुछ कुछ तो हो गया है।
Yes, have you gone through this?
Matlab, I have notification matlab, the last
Read it,
paragraph
read it,
matlab,
read it, read it.
matlab, clearly says matlab, the between the period from the last three lines from 14th
Yes,
day of
amendment. Have you seen the amended portion?
amended.
Amended portion, then two. Please read it.
We last from
Please
two
read the two in its entirety. In the last para of the word,
the words, the authorities, the director of local bodies, West Bengal, to issue orders according to the post facto approval.
to issue orders according post facto approval
Approval of appointment to promotions made by the municipalities against the sanctioned vacancies holding erstwhile scale of rupees such and such, since revised rupees such and below within the aforesaid period on
within the aforesaid periods made 14th day of July 1994, 30th day of September 23rd, 2003. Yes. On case to case basis, please read it.
After due examination to inquiry, the words to declare that initial appointment or promotion in respect of all other officers and employees not included in subsection 1 of section 54 of the West Bengal Municipal Act 1993 made by the municipalities against the sanctioned vacancies between the period from 14th day of July 1994 to 30th day of September 2003 shall be deemed to have been done as per extant provision of the West Bengal Municipality Act 1993 and as ratification of the state government
Shall be deemed.
Deemed.
And this notification has been issued after the order passed by this court in Nitai Chandra Singh. Yes, when you are appointed, your husband was appointed.
My petitioner is appointed in the year 90, my lord. His service was regularized on 8.
1995.
Yes, 1995, regularized.
Regularized 1997 in the promotion in the post of driver.
My lord, no, my lord, kindly.
Kindly comes to page 19.
19, yes.
Page 19.
Yes, my lord.
এই আমার ইয়েকে ডেকে পাঠাও তো একটা অঞ্জনকে। এক মিনিট, এই শোনো একটু বলো যে নিতাই চন্দ্র সিংহ অর্ডারটা থাকবে নিয়ে আসতে পাচ্ছি না। So, with effect from 1st of January 1995.
Yes, ma'am.
Initial appointment previous page 1990.
Initial appointment is not necessary. Please read page 19.
Yes.
Initial appointment after considering of service as consolidated pay. Employee in our municipality, the board of councillors in their meeting so and so decided to regularize you.
From 1995.
Yes.
So he is also coming squarely within the period from 1994 to 2000.
Yes.
And when he retired?
He died, my lord, not retired.
Oh, died. When he died?
2014.
2014, 9th September. 19th September 1914, 2014.
And when the municipality forwarded the papers?
My lord, I don't have the specific date, but in the year 2023, we have forwarded the service book of both the petitioners, but till date
Why
we didn't
don't you
receive.
After death in 2014,
No, previously also we have sent, my lord. Previously we have to send for the approval. We have sent them various letters, my lord.
Kindly come to page 23, Malad, there is a recording. The incumbent was appointed to the, Malad, notice there, Malad, chairman, regarding approval. Was appointed in the
Vacant post of driver.
the sanctioned vacant post of
Driver.
driver
Hmm.
on
as per
promotion.
promotion in the scale of rupees such and such with effect from 97 as approved to the said appointment is not regard approved by Board of Regulation dated 29th December 2015. Item number 9.
But he was placed on regular scale of pay. VDA order dated 8 March 1995. You are harping on a previous order of appointment, Vice Chairman.
That is only initial appointment 90.
No, my lord, regularized on 1995, my lord. No. Peon, water supply department. Subsequently promoted in driver.
So appointment is with effect from 1st January 1995.
1995.
Issue. And died on 19 September 2014.
19 September 2014.
Wife of a deceased employee of Kamarhati municipality has come up with the present writ petition, praying for sanction of terminal benefits, and release of family pension in her favor due to death of her husband in harness during service he retired.
Yes, yes.
In harness on 19 September 2014. Stop.
But he is getting family pension now paid for area family. That is
So
his.
family pension he's
Yes, Malad, he-
I am getting only 50%, my lord.
Well,
kindly case-
my lord, with our best efforts we are giving, but they are not releasing the money, and neither they are
He's-
releasing the service book.
so whatever has been paid, adjusting that amount you have to pay.
Yes, my lord.
But you have to regularize it. If the,
Yes, my lord.
if the municipality is paying this, municipality is not supposed to pay this.
Yes,
Why
my lord.
municipality will pay in its own coffer, from its own coffer?
Yes, my lord.
Malad, here hard pair is only Malad, the area family pension and get.
Yes, my lord.
As well as you have to pay the pension regularly. Who will
Yes,
pay the pension?
Full pension they want,
Malad,
right?
Getting
he
the
is not
gratuity
getting the
also.
family pension আমি পাই। আমি family
That
pension-
family pension is from the municipality.
Yes,
With
Yes,
our,
There is no sanction.
as per
So,
the
Malad, that is as
that is
per-
provisional pension we are giving.
Yes, sir. He will say. Stop. The learned advocate representing the petitioner submits on placing reliance on a letter of the chairman chairman of Kamarhati municipality dated 8 March 1995 that considering the past service of her husband the board of councillors in its meeting or board of councillors in their meeting dated 29th January 1995 decided to regularize the husband of the petitioner in the post of peon upon placing him on regular scale of pay with all other admissible allowances with effect from 1st January 1995. Stop. The deceased employee rendered service from 1st January 1995 till his date of death on 19th September 2014, but after and drew salary on regular scale of pay, on regular scale of pay. Stop. However, after death of the husband of the deceased employee on rendering service for approximately 19 years, terminal benefits including death gratuity was not released in favor of the petitioner, since it has been submitted by the learned advocate for the municipality that in spite of forwarding the necessary papers relating to service of the deceased employee, the director of local bodies did not take contemporaneous steps for sanctioning terminal benefits in favor of the wife of the deceased employee, being the petitioner herein. As a result whereof, the benefits which are payable to the petitioner due to death of her husband could not be released. Next paragraph. Mr. Ghosh, learned advocate representing the state respondents, including director of local bodies, has made an attempt to defend the stand of the state respondents on the score that on appointing the petitioner with effect from 1st of January 1995, on appointing the husband of the petitioner with effect from 1st of January 1995, perhaps formal approval was not accorded by the director of local bodies, and due to want of approval, the benefits which are payable to the wife of the deceased employee could not be released. Next paragraph. The issue appears to be no more res integra in view of the decision of this court delivered in the case of Nitai Chandra Singho versus so and so. In view of the in view of so and so, dated delivered in the case of so and so, video order dated so and so. Next paragraph. It has also been brought to the notice of this court that after the order was passed by this court in Nitai Chandra Singho Supra, an order was passed by the Additional Secretary to the Government of West Bengal, Department of Urban Development and Municipal Affairs, dated 6th February 2023. Whereby, upon bringing certain amendments to the government orders dated 7th May 2009 and 19th August 2009, empowered the director of local bodies ঠিক আছে। To declare initial appointment of the employees of municipality who were not of the employees of the municipality who were not included in included under subsection 1 of section 54 of the West Bengal Municipal Act 1993 and who were appointed by the municipalities against the sanctioned vacancies between the period from 14th day of between the period from 14th July 1994 to 30th September 2003 shall be deemed to have been done as per extant provisions of the West Bengal Municipal Act 1993. Municipal Act একটু দাও তো, ওই যে সবুজটা। Stop. On perusal of the appointment made in favor of the husband of the petitioner, as it emanates from appointment letter dated 8 March 1995 at page 19 of the writ petition, it appears that the deceased employee is not coming within the purview of section 54 within bracket 1 of the West Bengal Municipal Act 1993, and his appointment and his substantive appointment was with effect from 1st January 1995. Therefore, by virtue of the government order dated 6th February 2023, by this time the deceased employee should have been declared to have been appointed in terms of the extant provisions of the West Bengal Municipal Act 1993. নেক্সট প্যারাগ্রাফ। আচ্ছা, ওইখানে যে নিতাই চন্দ্র সিংহটা বললাম, ওটার এবার পড়ো, আমি রেফারেন্সটা বলে দিচ্ছি। Singh versus State of West Bengal others, being WPA 32668 of 2014, video order dated 24th March 2022. Next paragraph. Accordingly, the director of local bodies, government of West Bengal, being the respondent number 1, is directed to treat the husband of the petitioner as an approved employee of the concerned municipality and sanction terminal benefits, all terminal benefits in favor of the petitioner being the wife of the deceased employee, including family pension, within a period of 8 weeks from the date of communication of this order, upon compliance of necessary formalities. Next paragraph, with the aforesaid direction, the writ petition stands disposed of. There shall be no orders to cost.
সেকেন্ডটা শুধু নামটা
Yes,
change।
সেম বলছে দেখি, কিন্তু আর হবে না। Appointment date is also same.
No, my
Appointment date is not page 18. He was confirmed the board of commissioner in his meeting dated 90 of May 17 May 90. Services of the employees.
Just a minute, let me go through page 18.
Page 19,
Whether
my
the petitioner, who is the petitioner, wife or the
lord.
wife?
Wife.
The employee also died in harness.
Yes, ma'am.
What is the date of death? He said certificate is there. Just
4th December
4th
2011.
December 2011.
Yes, ma'am.
So it is his services from 1st of May 1990. 1st of May, শোনো ওইটা যেটা করলে মানে ওই একই ইয়েতে হবে, শুধু খেয়াল রাখবে ডেট অফ ডেটটা 4th December 2011,
And the post
appointment হচ্ছে with effect from 1st of May 1990.
and post was my lord different, Mazdoor.
Is not required.
Even my lord
An employee of the municipality, I have stated.
Yes, ma'am.
1st of May 1990 থেকে appointment, আর date of death হচ্ছে 4th December 2011. একই ফরম্যাটে ওটা ফার্স্ট ওটা করবে, করে এটাকে ডিসপোজ অফ।
Deeply obliged, my lord.
For the petitioner led by Mr. Obhijit Basu appearing virtually, my lord. But I appear for the respondent Kolkata Municipal Corporation. On the last occasion, my lord was pleased to pass an order on 5th of February.
Yes.
My lord was pleased to pass an order on 5th of February. Your lordship has certain queries to the learned advocate of the petitioner. His adjournment was made for answering that question. But apart from that, your lordship was pleased to record that on the last occasion, possibly the opposition, my lord, which has been filed by us, it is not on record. And therefore, my lord, your lordship was pleased to grant time to file opposition. And it has also been submitted that it has been affirmed. I find that it has been, my lord, affirmed and served. Reply has also been given. But if it is not in your lordship's brief, then, my lord, I may have to, my lord, reaffirm that affidavit. It was affirmed on 6th August 2018. It's a big one. It's a big one, my lord.
Reply is there. Affidavit in reply of the petitioners?
Yes, my lord. Then, my lord, possibly by some reason, my lord, it has been misplaced or, my lord, it has not been served. Submitted. No. Private restaurant goes to inspector, private restaurant goes to private restaurant number. 7 to 40. আমার কতজন হবে? না, আমি যদি 38 আর ওরা 30।
Mr. Basu, could you
Yes,
hear?
sir. Yes, I can hear.
Mr. Ghosh is appearing for the corporation. He is praying for accommodation to reaffirm the affidavit in opposition since the opposition is not on record.
I am not objecting to that, and for my part also, although it is the interest of the clients that I argue before your lordship physically, I could not go today. But if your lordship kindly fixes a date after the first week of March, or any day subject to your lordship satisfaction, I can be there and argue. And whatever, we will complete that argument on that day. Your lordship wanted me to explain those two judgments, which I shall explain.
Certain points, to explain certain points.
Yes.
Yes, very, you reaffirm.
There is another issue. It is also to be ascertained, because the petitioner's numbers are about 31 and private response also 37 or 38. Perhaps, my lord, in the meantime, the number of petitioners and both the respondents have already retired. I'm to ascertain
Yes.
that he's questioning about the promotion and all other things, apart from the question
No,
it has
no.
in question. But as far as I find out the deponent of the writ petitioner, he had already died because he was 58 at the time of affirming the affidavit. But now he said 14 in the year 2014 he affirmed the affidavit. Now it is 2024. Therefore, my lord, he had already died. Yet it has also been asserted.
He has retired.
He had already died.
Deponent has retired.
Had retired. And possibly he has been getting the pensionary and other benefits also. Therefore, wonder how many petitioners and how many respondents have, yeah, because all of them had already to the
Mr. Ghosh, you do one thing, you reaffirm the affidavit.
my lord.
Because otherwise, today, if you want to file a fresh affidavit,
No, I'm not filing fresh affidavit because whatever the
you
affidavit.
reaffirm the affidavit, but make a note regarding the present position of the petitioners vis-a-vis private
respondent. My lord.
Yes.
Only one petitioner is still in service. Only one. Others have retired.
This writ petition, Mr. Ghosh, learned advocate representing the Kolkata Municipal Corporation, has prayed for accommodation to reaffirm the affidavit in opposition, which was a copy of which was served upon the learned advocate for the petitioners, since the affidavit in opposition is not available on record. Next paragraph. Let such reaffirmation of the affidavit in opposition be made by 7 days from date. Stop. Mr. Ghosh is Mr. Ghosh is also requested to prepare a short note indicating the indicating how many petitioners are in service as on date and how many petitioners are alive. Stop. Mr. While preparing this short note, it is
also the respondents. So what are the private respondents are also?
While preparing this note, Mr. Ghosh will also indicate the present position relating to private respondents. Next paragraph. List the matter under the same heading for further consideration on 14th March 2024. 14th March.
14th March. I'm grateful.
Item number 9.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Same situation prevailed on 8 February 2024. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Intima defini stands vacated. Urging xerox certificate. Next.
Who needs the facility?
Item number 10.
I am for the petitioner.
I am here for the case.
On the last occasion, I was to at the page of 83 or input order.
Is it? Complying with the order of the municipal commissioner, one hearing was taken by the undersigned on various occasions under Section 397 of the KMC Act. The hearing was taken on the basis of an objection letter from the Secretary KIT, where it was categorically mentioned that an illegal construction is going on the premises on the ground that the land belongs to them and they have paid for revocation of sanction plan if issued by KMC immediately. All parties concerned were present during the hearing. Secretary KIT was present at the hearing. The engineers of the building department KMC was present and they have submitted the following office order number. One individual was sent to KIT authority requesting them to send their views regarding sanction of building plan on the premises, but they did not turn up within specific time and after elapse of 45 days from the date of challan issued by the KIT, building department have issued the sanction plan. As per observation of the Secretary KIT, the entire land belongs to KIT only, which was earlier informed to the applicant by KIT letter such and the KIT acquired land under KIT scheme, and they further requested KMC to revoke the sanction plan on the premises immediately. On 12 March 2014, the undersigned ordered
When the plan was sanctioned?
Plan was sanctioned by 11 March 2013.
Where from you are getting? Is it
It's page 77, my lord.
Page
77.
11th March
2013. Page 77, the plan as I have annexed my.
Just
and Mr. Ghosh also submitted the document. I just please it.
Yes. Then
on 23rd, and then now the opposite portion order, I have perused both the report.
just a minute, on 12 March
On 12
2014,
March,
please,
the
yes.
undersigned ordered for joint inspection in the presence of the Chief Valuer Supervisor of E Branch Secretary KIT of the and the applicant Om Prakash Singhania at 11:30. Pursuant to that order, joint inspection was taken place and report was furnished by the Chief Valuer in charge KIT and the Chief Valuer Surveyor KMC. So the two reports were submitted by both the department. Now, my lord, I have perused both the reports filed by the KIT and KMC, and after inspecting the record regarding premises and considering both the reports, I am of the observation that as the property belongs to KIT, as per their report, not all other documents, observation that as the property belongs to KIT, as per their report, no person.
I have paid just paid both the reports for the KIC. Yes, as per reports.
As per reports. He said there is joint inspection.
Whether these reports were supplied to you?
Initially, not supplied by, I got it by RTI.
After the order was passed?
After it was passed, the matter was because just.
No, this order was passed on.
Yeah, this order was passed on, my lord.
June 2014. 23rd June 14, when you got the report?
My lord, what happened when before this, the matter was pending with the High Court regarding the revocation, that stoppage of the stop work of the work. This order is there, and when the matter was, I'm moving this petition, they came and said that now order was already passed. So Justice Bakshi this program give me liberty to file the fresh petition against this order. Then I sought for all those documents from the KIT as well as from.
Then these reports were supplied.
They have not given. I am coming on. The report was given by the KMC or KIT has not given. So then I got the report. So after order, I got the report. That is, I'm showing you the document.
Just a minute. Municipal Act now. KMC Act 1980. Yes.
So, my lord, reason be recorded. Here he has recorded, joint council recorded.
Now, Mr. Talukdar, it appears prima facie, it appears subject to hearing all of you, that I have perused both the, come to page 83. I have perused both the reports filed by KIT and KMC, and after inspecting the record regarding premise and considering both the reports, I am of the observation that as the property belongs to KIT as per their report, no person should be allowed or caused any construction on that premises. So therefore, it appears that based on this report, decision was taken. Joint inspection, then reports of KMC and KIT, these were taken into consideration. Now, if you come to section 397 of the Act, which has been applied while passing order on 23rd of June 2014.
Just order to the page.
Come to section 397. Read it.
If at any time after the communication of sanction or provisional sanction to the erection of any building or the execution of any work, the municipal commissioner is satisfied that such sanction or provisional sanction was accorded in consequence of any material misrepresentation or any fraudulent statement in the notice given or information furnished under section 393 or section 394 or section 395, he may by order in writing cancel for reasons to be recorded such sanction or provisional sanction, and any building or any work commenced, erected or executed shall be deemed to have been commenced, erected or executed without such sanction and shall be dealt with under the provision of this chapter.
Then provided
that before making any such order, municipal commissioner shall give a reasonable opportunity.
So is it not the duty of the municipal commissioner to supply the reports based on which decision has been taken?
Well, that was done.
No, Mr. Rai is submitting that after this order was passed, reports were supplied.
On the RTI application, my lord. Even not by KIT.
The person has been terminated from service, and thereafter, if the reports based on which termination was made, if those reports were supplied later on, then what is how this reasonable opportunity can be construed?
My lord, kindly.
Where is Mr. Ghosh?
If your lordship kindly takes up the joint inspection report at page.
I am not on this. I will not take up joint inspection report at this stage. There is a joint inspection report. Last but one penultimate paragraph is very important, page 83. I have perused both the reports filed by the KIT and KMC, and after inspecting the record regarding premise and considering both the reports, I am of the observation that as the property belongs to KIT, as per their report, no person should be allowed or caused any construction on that premises. So these reports played important role in order to persuade the authority to pass order under section 397. Is it not the duty of the corporation to supply the reports in order to comply the reasonable opportunity of hearing?
My lord, the order the preceding paragraph records.
No, maybe preceding paragraphs may be one of the reasons. But if certain materials are taken into consideration by the corporation, and if these materials are not supplied to the party who has suffered the order, when section 397 provides so specifically provides for reasonable opportunity to be afforded to the petitioner, then where is the compliance of that requirement? So far, natural justice is concerned. You are not in a position because your case is that this land belongs to you, therefore no sanction plan can be accorded in favor of the petitioner.
And this information.
But the decision has to be taken by the municipal commissioner.
This information obtained by the petitioners from us, but without suppressing that information, they applied for sanction.
This court, what is passing through mind of this court is this, that let these reports be supplied to the petitioner, let a fresh decision be taken. After granting opportunity to the petitioner to make deliberation before the commissioner based on these reports. Because if the construction which has been made by the petitioner is demolished, that is irreparable loss.
My lord, here subject to correction by your lordship. In 397, it's a prime cause is misrepresentation, suppression of material.
That formation of opinion of misrepresentation of misrepresentation is based on reports. There are certain other reasons. One of the reasons is the two reports of KMC and KIT. So if these reports are not supplied to the petitioner, how the compliance of natural justice has been followed by the authority as it has been contemplated in the proviso to section 397.
My lord, in the joint inspection, the petitioner was a party to that. Petitioner was party to
yes,
joint inspection. Yes. Which has been referred to in the order impugned. And in fact, it is an admitted position, my lord. Suppression is admitted position. The petitioner cannot deny. Before applying for sanction, the petitioner.
I want to see whether these reports were supplied to the petitioner or not. Yes, you are absolutely correct. Under section 397, unless and until it has been that material misrepresentation or fraudulent statement has been concluded by the authority prior to passing an order under section 397, these are the requirements, that either there must be a material misrepresentation or fraudulent statement. According to the authority, there was a material misrepresentation by placing an application under section 397 declaring the land by the petitioner, that land belongs to petitioner. But in effect, this is the land of KIT. But while passing an order, rightly or wrongly, an sanction plan has been accorded. Based on sanction plan, construction has been made. Construction is not complete, but construction has been made by the applicant. At material point of time, corporation also approached you, did not respond as it has been recorded in the order. Had there been a timely response from the KIT, then this thing could have been avoided. Issuance of plan could have been avoided so far the petitioner is concerned. KIT was not vigilant enough at that point of time. After construction is made, KIT woke up from some slumber. Yes, this is my land. And it was stated that in the month of February, or 1st of August 2012, it was informed to the petitioner. All parties concerned were present during hearing on so and so. On 1st of August 2012, stating that KIT acquired land. So this was on 1st of August 2012. Plan was sanctioned on 11th of March 2013. Had it been communicated to the KMC prior to sanctioning plan on 11th March 2013, then question would have been different. Then KMC would not have sanctioned plan in favor of the petitioner. Now, when a decision has been taken under section 397, now this decision must be on compliance of the requirement as contemplated under the first proviso to section 397.
Yes. What
So reasonable opportunity of hearing, what does it mean?
Yes.
You have to follow all the materials. You have to supply all the materials to the parties based on which decision was taken by the KMC. Mr. Rai is submitting that yes, this was supplied to him. But when patient died,
But the petitioner was aware of this.
whatever may be, the
Aware of this, he was
opportunity of presenting case has to be afforded to the petitioner.
That was
If you do not supply this joint inspection reports, where is the opportunity granted to the petitioner?
one paragraph from our affidavit. May
I want to hear the corporation, because you are not the authority who has passed the order. Where is Mr. Ghosh?
Mr. Ghosh will be coming. He told me that is just one matter is about to be called.
Where will Mr. Rai come back?
My lord, one thing may I say.
You will not submit anything now, because it is your land. You have suffered the order, but the order has been passed without supplying materials. Yes.
Regarding the suppression, there are materials, my lord.
But the opportunity has to be given. Where is that opportunity if these materials are not supplied? I have made a construction on obtaining sanction plan. Now I have to demolish it.
Yes.
Now, so therefore, after demolition, it's an irreparable loss. It cannot be restored back.
Of course, Mr. Ghosh will answer this. My lord, we have in our affidavit the steps taken regarding
representing the petitioner and Kolkata KIT, Kolkata Improvement Trust. Stop. Mr. Rai, learned advocate representing the petitioner, has placed the order dated 23rd June 2014, passed by the concerned authority of KMC in terms of section 397 of the Kolkata Municipal Corporation Act 1980. On perusal of the said order dated 23rd June 2014, it appears that the decision was taken to withdraw the sanction plan based on reports filed by the KIT and KIC and KIT and KMC after the joint inspection was made. According to the petitioner, these reports of KIT and KMC were not supplied to him prior to taking decision on 23rd June 2014, whereas proviso to section 397 of the KMC Act postulates requirement of affording reasonable opportunity of being heard to be even postulates affording to the petitioner. To the petitioner. Stop. Next paragraph. This court wants to hear the learned advocate representing KMC who is not present in court today. Are you in a position to clarify? This court wants to hear the learned advocate representing KMC on the aforesaid point. Mr. D. learned advocate representing the KMC has prayed for accommodation to come better prepared. Next paragraph, hearing of this matter stands adjourned till 14th March 2024.
Instead of 14, any other day, 13 or 15.
No, these matters are
That's just Thursday. Very well.
I'm going to write. Yes, my lord.
no, once demolished, nothing can be done.
Yes.
Yeah, that's true. But there are materials. my lord.
Yes,
There are materials.
but the opportunity should be granted to make deliberation before the.
My lord is,
before the-
I followed that.
Yes. দাও। এসো। On 8 February 2024, the writ petition being WPA 19135 of 2017 was considered by this court along with the writ petition being WPA 16794 of 2016. And direction was given to list both the writ petitions today, 29th February 2024. Stop. Next paragraph. However, on perusal of the order passed on the writ petition being WPA 19135 of 2017 on 24th July 2023 by this court, it appears the said writ petition stood dismissed due to non-appearance on behalf of the petitioners. Stop. Therefore, the direction as contained in order dated 8 February 2024 in connection with the writ petition being WPA 19135 of 2017 stands recalled. Stop. The department is directed to treat the writ petition being WPA 19135 of 2017 not pending and same shall not be and same shall be reflected on the system. Full stop দেবে না, in view of the order dated 24 July 2023. Let the writ petition being WPA 19135 of 2017 be detached from the writ petition, be detached. Stop. নেক্সট প্যারাগ্রাফ। এবারে ইনরি WPA উপরেরটা করে দেবে কি ইনরি WPA 19135 অফ 2017, নিচেরটা করবে ইনরি WPA 16794 অফ 2016। The writ petition was taken up for consideration on 25th January 2024 and subsequently on 8 February 2024, when no one appeared for the petitioners and no accommodation was prayed for. Today, at the time of call, no one appears for the petitioners. Stop. It appears the petitioners have lost interest. Stop. Accordingly, the writ petition stands dismissed. Intimata fini stands vacated. Urgent stands vacated. Stop. Applications. If application code. Application, comma, if any pending also stands dismissed. Urgent xerox certificate. Next.
Item number 13.
I'm appearing for the KMC led by Mr. Shubhranshu Pandalot.
Issue. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, next paragraph. However, Kolkata Municipal Corporation is represented by learned advocate. Next paragraph. Same situation prevailed on 8 February 2024. Stop. It appears petitioner has lost interest. Writ petition stands dismissed. Intimata fini stands vacated. Urgent xerox certificate copy. Next.
Item number 14.
On behalf of the petitioner, my lord's last order of 18th of January 2024 plan cancelled because I had, my lord, taken the plan on encroached land, government land. My lord directed an inquiry, my lord, on 18th of January 2024. The inquiry report, my lord, is
Just a
outside.
minute. Just a minute. Let me go through. Yes.
Yes. Well, after my lord's order, my lord, and a fresh inquiry was conducted, and this is the report on the basis of that fresh inquiry. A copy of the report, my lord, is hereby handed over to my lord also. আপনি সকালে যখন বাড়ি থেকে বেরিয়েছেন আমাকে বলে যান। সরি, কি বললে? তাই না? সৃষ্টি করতে ওই দেখি ওইটা কি অরিজিনাল ছিল না? সত্যি এইটা অরিজিনাল ছিল। একটা দেখি এইটা অরিজিনাল ছিল। মানে অরিজিনাল মানে এটা এইভাবে করেছিল, ট্রেস করে করেছে, ট্রেস করে দেখে জেরক্স এটা।
The red colored portion which is stated vest.
I'm very sorry, my lord. My lord, Lordship, kindly take this, my lord. I think this is the original for my lord's copy, my lord. Lordship, kindly, my lord. I'm very sorry, my lord. Because, my lord, this is the, my lord, the original. That was, my lord, the
This
copy.
part.
Yes, yes. Now, my lord.
Out of this part which falls on dag number 126.
Yes, yes. Now, my lord, kindly have a look once again, my lord. This, my lord, this is the, my lord, the vested, my lord, the red mark in the middle. This is the vested, and at the bottom left hand side, my lord, the corner is a small indication, the deep red by square within the vested.
Yes, Mr. Banerjee.
I'll have to
What
file a
will-
suit. I have to file a suit now. There's nothing that I can do in it. Only one prayer. Let me just go back, come back to your lordship within a week. Check this up. Otherwise, suit. Nothing in writ.
This is the last resort so far this court is concerned.
Otherwise,
in order to
it is
find out
beyond
the
the pale of
veracity
the
of the order.
My lord has already stretched the writ court's jurisdiction to the maximum. In this, if I have anything, any axe to grind, this cannot be the part of writ court jurisdiction.
You want 1 week time to come back?
May I have 2 weeks? Just come back.
No, next Thursday.
Achha, okay.
Pursuant to the order dated 18 January 2024, a report dated 6th February 2024, prepared by the Block Land and Uniforms Officer, Kolkata, South 24 Parganas, along with sketch map, is placed before this court and the same is taken on record. During course of hearing, copy of the said report dated 6th February 2024 is made over to Mr. Banerjee, learned counsel representing the petitioner. Stop. The learned advocate for the petitioner has prayed for accommodation to
Consider the report.
To consider the report and in order to make further submission. Stop. Hearing of this matter stands adjourned till Thursday next, 7th March 2024.
Great. আর কি করতে পারি? That you believe এই ইনফরমেশনটা আমার কাছে ছিল, আমি তো কখনো কোনো অবস্থাতে জুনিয়র
Number 15. Lordship, for the petitioner, my lord. As per your lordship direction, my lord, we have served the private respondent again the notice. Service has been effected, my lord.
Lord, I have been instructed to appear on behalf of the private respondent.
Have you served notice?
Yes, sir.
Who you are appointed? Private respondent. And municipality?
I am not the minister.
English Bazaar municipality. Yes, what is the matter?
My lord, upon filling up the pond, which is a Devottur property, an unauthorized construction has been created. And my lord, before that, my lord, may I place the order, lordship's records also there, 16/8/2019. My lord, Justice Shamathi Chatterjee, as his lordship Diden was pleased to pass this order, demolish that particular unauthorized portion. That was a directive from the municipality. And that was not been done. After that, the municipal authority filed an affidavit in opposition, my lord. And in opposition, they have disclosed.
Now, here you have made a complaint for unauthorized construction.
My lord.
So, where is that complaint?
My lord, it starts from
page 51.
46 onwards. Extra copy. No, extra copy. এটা হলো কত হচ্ছে ওর বার করেছিলাম আমি মানে ক্যালকুলেশনটা আমরা করেছি
Now, based on this complaint, whether any action has been taken by the municipality?
No, but in reply to that, they have given the reply that they have the municipal authority given a sanction authority. Lordship, kindly take my reply once, my lord.
Municipality has accorded sanction plan.
Accorded sanction plan to the private respondent. That's why they have created this construction. Kindly have a look my reply once, my lord.
Reply.
Reply.
Affidavit in reply.
Affidavit in reply of the opposition of the municipal authority. Page 6, paragraph 10.
Opposition of the municipality.
Municipality. Because private respondent earlier did not appear, my
Page 6 is
page 6, paragraph 10. Lordship, kindly skip first 4 lines and sentence starts with I state. May I please?
Yes.
I state that although the municipal authority has sanctioned the building plan in favor of the private respondent bearing sanction number such and such dated 7th December 2017 on holding number such and such for constructing G+2 building, but the said sanction plan was also made in violation of the provision of the law. I state that private, can you take a look, Your Lordship? I state that the private respondents are the owners of the RS plot number 143, LR plot number 738 by 1187, as shown in the record of rights. In the said record of rights, the total area of plot was shown as 057 acres, that is 2482 square feet. But the private respondent have obtained the plan for area of 2655 square feet.
Now, that is not under challenge in this writ petition.
No, it was subsequently, it was disclosed the fact.
Therefore, I can grant you leave to file fresh writ petition challenging the sanction plan.
But my lord,
what is your prayer in the writ petition that your complaint is not
my prayer was that regarding the unauthorized construction.
Complaint is not taken care of.
Yes.
Now the municipality is saying that we have accorded sanction plan.
Yes.
Now if the sanction plan is accorded, it gives rise to a fresh cause of action.
And may I pray one submission, my lord? As it was disclosed by the municipal authority that they have accorded the sanction plan, and I have collected information on the basis of the records of the government. May I pray for send it back to the municipal authority? Let there be hearing.
What for?
Because of the fact, if it is found that the excess sanction plan they have given, which is beyond the scope.
Municipality has granted a sanction plan. Had there been no sanction plan, then I would have directed the municipality to initiate proceedings under section 218 of the West Bengal Municipal Act 1993. Since the sanction plan has been accorded, and you are questioning the sanction plan that it has not been properly accorded, you have to file a fresh writ petition questioning the sanction plan.
Subject to can sanction.
And that validity and legality of the sanction plan cannot be assessed in this petition, considering the case made out.
Subject to can sanction, my lord.
Because already today construction is complete.
Yes, it is completed because there was a direct. Can you consider this order, my lord, which I have handed over to your lordship?
May I indicate one thing, my lord? Irrespective of this, my lord, a suit has been filed at their instance, seeking recovery of possession from our saying that we have encroached. In that suit, my lord, injunction order was vacated by the trial court, and no steps have been further taken.
Does it mean unauthorized construction?
My lord, only one thing. They say, my lord, we have encroached, and thereby they paid for, my lord, recovery of possession before the trial court.
Any legal steps is taken by the petitioner in future questioning the sanction plan, then this order of the civil court will come in your aid. Yes. The writ petition is heard in presence of the learned advocates representing the petitioner, English Bazaar municipality and the private respondents. Private respondents. So, it has been submitted on behalf of the petitioner that though writ petition was filed for non-consideration of the complaint dated 24th September 2018, which is at page 46 of the writ petition, which was lodged before the concerned authority of the municipality against the construction which was being made by the private respondents. But during course of hearing, it has been informed that the municipality has already accorded sanction plan in favor of the private respondents.
And my lord, that was prior to the filing of the writ petition.
Opposition.
Writ petition.
Being number 35/2017-18, 2017-18, dated 7 December 2017. Stop. However, in paragraph 10 of the affidavit in reply, the petitioner has made out a new case in order to question the plan sanctioned in favor of the private respondents. Stop. Next paragraph. Considering the prayer made in this writ petition, which centers around the complaint of the petitioner dated 24th September 2018, the challenge which has been attempted to be thrown against the sanction plan dated 7 December 2017 cannot be delved into in this writ petition. Stop. Next paragraph. Accordingly, the writ petition stands disposed of, thereby granting leave to the petitioner to take steps in accordance with law against the plan sanctioned in favor of the private respondents, if so advised. There shall be no orders to cause or danger of support.
This leave was not required.
Yes, otherwise, I cannot get the chance.
Because my lord,
affidavit service filed on behalf of the petitioner is taken on.
And my lord, land in question. My lord, land in question, my lord, there is a Pukut par. It's kind of record this, my lord.
Next.
Well, I'm grateful, Lord. Not been
I am for the petition.
No, subsequently managed.
Item number 16.
So item number 16, I am for the petitioner, Lordship, virtually. I am happy, Lordship. I may be permitted. Lordship, at the outset, Lordship, I would submit that, Lordship, my brief has already been misplaced, Lordship. I will request your Lordship to please, Lordship, kindly make an arrangement, Lordship, so that I can make a Xerox copy of the course brief.
Previously.
Lordship, yes, I appeared previously, Lordship.
February 2024, no one appeared for the petitioner. Then on 8 February 2024, accommodation on 8 February 2024, accommodation was prayed for on behalf of the petitioner.
Yes.
So therefore, how long I will go on adjourning the matter?
No, certainly, Lordship. Lordship, can give me 1 week time, Lordship. Lordship, I will arrange the brief, Lordship, from your Lordship brief, Lordship. Then I will argue the matter, Lordship. Otherwise, I am ready because affidavit has already been exchanged.
This matter is running in the list for quite some time. 1st February 2024.
True.
Today you are saying that brief is not traceable, and court will wait when the brief will be traced out.
So 1 week time, Lordship, maybe given, Lordship, by that time, Lordship, I will arrange the brief, Lordship.
At the time of call, previously also last chance, a matter was adjourned.
True, Lordship. I will do the matter, Lordship.
At the time, accommodation has been prayed for on behalf of the petitioner. Stop. no one is representing the respondents today. Next paragraph. Though adjournment was granted in favor of the petitioner previously on prayer being made, comma, hearing of this writ petition stands adjourned till next till Thursday next 7th March 2024, when it will appear at the top.
Lordship. Oh, yeah. Lordship,
Yes.
I may be allowed to, Lordship, make a Xerox copy of my from Lordship.
This is a hearing day. Since certain matters are adjourned, that's why your matter is called on. Now, next day, when those matters will be taken up, these matters will not be called on your matter. And
No, I'm ready. I'm ready otherwise, Lordship.
This
I may be.
It will be at the top of the list.
Sure. Lordship, I may be allowed to take a Xerox copy, Lordship, from your Lordship deed.
No, that is not permissible.
Lordship, otherwise, Lordship, I may be allowed, Lordship. Otherwise, Lordship, that will be difficult for me, Lordship, to get the copy. That's why I traced out at my chamber, Lordship, I couldn't find.
Copy from the record of this court. You have to take steps in accordance with law. You know what steps are required to be taken. I am not to advise you.
Lordship.
But on next day, if prayer is made that you want to obtain certified copy of this order, of this writ petition, I will not permit you. Keep it in mind.
Now matters.
First adjournment, you will not appear, it will be adjourned. Then you will appear, pray for time. Then you will appear and say that no, brief is not traceable. And on the next date, you will pray for time to obtain certified copy of the writ petition. This is not permissible.
That's why, Lordship, I'm praying for small indulgence.
Now matters from combined monthly list.
It's a topic diye debe. Yes.
Published on 5th February 2024. Item number 166.
My lord, I appear for the petitioner. My lord, this matter, your lordship, once upon a time, heard it substantially. Subsequently, my lord, determination changed. Kindly come to order dated 4/8/2022 of your lordship. Subsequently, my lord, there was a change of determination. Again, it is before you.
4/8/2022.
4th
August 2022. Just a minute.
Oh, that's right. One at Titagar Municipality Advocate.
Yes. But how this will be treated as a group 5 matter?
Well, irrespective of classification.
It was heard on
Municipality
4th August 2022
Yes.
by this court when this court was having the determination to take up
Hearing
hearing matters irrespective of classification.
Irrespective.
Today, this determination is not, this court does not have determination to
Your
take up
Lordship, I think, have
matters irrespective
municipality
of classification.
determination.
Only group 5 matters, but this cannot be treated as a group 5 matters. You have filed as group 5 matters since the school is run by Titagar municipality.
Titagar municipality.
But the matter pertains to appointment of primary teacher.
Primary teacher. So, my lord, there can be.
According to you, that there was a violation of National Council for Teachers Education notification dated 23rd August 2010.
2010.
So therefore, matter relates to appointment of primary teacher.
So, my lord, two determination. One is it is a municipal school. So,
Maybe.
your lordship remembers that the municipality submitted that we are not bound by NCT, which I think at that point of time your lordship was not
School
with
is
the
administered by the municipality.
municipality.
But matter relates to appointment of primary teacher.
Matter relates to appointment of primary teachers. So there,
If I had the determination to take up matters irrespective of classification, then I could have.
but my lord,
Today I
yeah,
have a determination of group 9 as well as group 5.
group 5.
So group 5 determination, this matter is not coming.
My lord, group 5, my lord, I respectfully submit, my lord. Group 5 determination, my lord, this relates to municipal schools in the state of West Bengal.
Maybe.
The school is not under.
It is relating to teacher.
But well, kindly,
School run by any run by the municipality.
kindly allow
to
me to
convert this writ petition.
but-
I will grant you leave to
kindly allow me to submit two
reclassify
things.
the writ petition and the presentation form of the writ petition be amended.
Then your lordship will be taking up.
I will not take up. I will release the matter.
Well, just kindly allow me to submit two things. Respectful sub. If maybe I am wrong, your lordship may not be with my view. The fact, my lord, is that these are municipal school, not under the education department. Primary teacher, which your lordship takes before this honorable court takes, or whatever may be, these are all under.
List also. এই তো এখানে ছিল, এই তো কম্বাইন্ড লিস্ট, এই কম্বাইন্ড লিস্ট থেকেই তো হচ্ছে। ও ফার্স্ট পার্ট 1টা দিতে হবে, ঠিক ঠিক। Education matters.
But overlapping determination, my lord.
Education matters.
Overlapping.
If it is an education matters, educations including service.
Educations including what will happen to my lord municipal service?
If
This is a municipal service also.
If the school is run by railway authorities, what will happen?
My lord, railway authorities, if it have to go to the central administrative tribunal.
If it is if the teachers are service of the teachers are governed by the railway authorities, then one thing. But there are certain schools where the support comes from railway authorities, on the land of the railway school situates, but the services of the employees of the school are not governed by the central act and rules. Then
Lord,
what will happen?
Overlapping determination is there, my lord. Kindly visualize, my lord. Your lordship has already substantially heard also this matter.
What can be done? Yes, you are absolutely correct. I heard this matter when I had the determination to take up matters irrespective of classification. Then this issue was not germane. But today, since I am taking group 5 matters, how I can take up this matter?
Well, overlapping determination. Municipality, after all, it's a municipal school. So it is under the municipality. So if the municipality takes any, my lord, I will make, let all the parties may come, my lord, I will make submissions on this. Your lordship may not be satisfied. Your lordship may have a view, but I may be right. But both determination, primary as well as municipal. Suppose the municipal department thinks that we will run schools and the services of the municipal employees or the appointments is made by the municipality is concerned. Monthly Group 5 municipality জায়গাটা খুলো। Municipality জায়গাটা খুলো। Municipality জায়গাটা খুলো না। যাত্রী সৌগতটা যদি জায়গাটা খুলো।
After hearing Mr. Banerjee, learned advocate representing the petitioner, it appears that the issue involved in this writ petition pertains to appointment of primary teacher in a school which is run by Titagarh municipality. Stop. Since matter relates to appointment of primary teacher in a school which is under challenge, the writ petition needs to be reclassified as group 2 matter. Next paragraph. Leave is granted to the petitioner to amend the presentation form and pro forma page of the writ petition. Leave is granted to the learned advocate for the writ petitioner. Leave is granted to the learned advocate for the writ petitioner to amend the presentation form and pro forma page of the writ petition. Stop. Next paragraph. The writ petition stands released from the list. Sorry.
Item number 167.
The respondent.
Who is for the petitioner? Vidhannagar municipality. At the time of call, no one appears for the petitioner and no accommodation is paid for petitioners and no accommodation is paid for. Next paragraph. However, Vidhannagar Municipal Corporation is represented by learned advocates. Next paragraph. List the matter under the heading Motion Group 5 Municipality for Disposal. Motion Group 5 Municipality for Disposal, quote unquote. Motion Group 5 Municipality for Disposal on March 11th, 2024. However, it is made clear if on the urgent date petitioners go unrepresented, consequential order shall be passed. Next.
Item number 168.
Lordship, I am for the petition in this matter. The matter is relating to illegal construction.
Use microphone. Yes.
The matter is relating to illegal construction. Lordship, in the...
Is there any private respondent?
Yes, Your Lordship.
Now, what was the order passed by the coordinate bench at a motion stage?
It was not it was appeared in the motion in the list, but it was dismissed for default, and after that we have filed the restoration application.
Yes,
it was allowed.
Yes, I've seen the order. It is restored. Yes.
Yes, that's
now. So therefore, there was no direction for any affidavit.
No.
Now you are complaining of construction made by the private respondent.
Private respondent.
Which municipality is involved?
Kandi
municipality. Who appears for the municipality? Kandi municipality. Pratip Chatterjee appears.
That I do not know.
They will serve notice upon the respondents and come back.
Yes, sir.
The writ petition is taken up for consideration in presence of the learned advocate representing the petitioner. Stop. However, no one represents the respondents today. Next paragraph. The learned advocate for the petitioner is directed to serve notice upon the respondents or the learned advocates representing the respondents, enclosing order passed by this court today by fortnight from date and file affidavit of service on the urgent date. Stop. Next paragraph. List the matter under the heading Motion Group 5 Municipality for Disposal on.
Lordship, may I interrupt? Lordship, we had direction for affidavit of service, and we have prepared that, Lordship.
That is in connection with that affidavit of service.
The year 2020.
LP,
Yes, yes, Your Lordship.
21st March 2024.
That's good.
Serve and come back.
Yes, Your Lordship.
Item number 169.
I for the petitioner, my lord, led by Mr. Mojumdar, my lord. This matter, my lord, relates to municipality service, my lord. The petitioners claim permanence in their service with the respective municipalities, my lord.
Who is appearing for the municipality?
My lord, there are several municipalities.
Okay.
Yes.
There are several municipalities.
Oh.
My lord, state was supposed to file affidavit, my lord, as per the direction.
How many petitioners are there?
24, my lord.
So they are working in different municipalities.
My
Why by filing one writ petition?
This point was taken up before the coordinate bench, my lord. Thereafter, the coordinate bench was satisfied that this can be, because they are all similarly situated, my lord, and all were appointed through the same process.
Their posts are different, municipality is different.
My lord, state is one of the main.
Show me the order passed by the coordinate bench. Which order? Mr. Banerjee, you are appearing for which ministry?
I'm for Halishore.
Yes. By which order?
Madam.
Subject to the recollection, what happened was in this matter, the policy of the state was supposed to be adhered to.
Yes.
The learned single judge, Millard, at that point of time, Millard, was considering that whether as a matter of policy, because Millard, though the municipalities are different and independent bodies, Millard, the guiding principle comes from the state, Millard, so far as the service is concerned. Now, Millard knows there is a municipal service commission also, Millard. So the appointments have now no more is not with the municipalities.
Everybody knows that there is a municipal service commission.
But that's what I'm saying. So that was the policy was the thing, Millard, that was taken into consideration, and that's why the matter was being heard, Millard, and the state was supposed to.
What is the policy which is involved in this matter?
Millard, this is with regard to if this the architecture matter, so.
এটা হচ্ছে the accounts.
Accounts. Here,
the department.
The department has to finalize, Millard, because they wanted a change in the service category. If I'm not.
They want the permanence in the. There is a report of the state also in my favor, my at page 127, my lord.
Different policies for the.
Let me see what you are praying for. So they are not the permanent employee. They are not working on substantive basis. You are praying for permanent.
That is my prayer.
You are praying for permanent. So whether the state is the appropriate authority, director of local bodies.
Yes, my lord.
So who is appearing for the state?
Mr. Shondip Mondol was there, my lord, led by Mr. Jawaharlal De, my lord.
Mr. Dey is no more in the panel.
Mr. Dey is the government leader.
Again, he has come.
He is reincarnated.
A new panel has been.
A new panel, and yes, his name is figuring out.
Then you serve notice and come back. Whether they have used any affidavit.
No, till date I have not received any affidavit.
Direction for filing affidavit.
Yes, my lord. By a letter, I also reminded them that you can.
Whether the any of the municipalities
have filed
some of the municipalities.
Not what is your stand?
Practically, if your lordship goes by our affidavit is concerned, we are more or less supporting their stand. If there is
No decision has been taken by the director of local bodies.
No, not yet.
No decision is under challenge, as I find from the
In fact, Lordship will find from page 17, just as indicated by Junior, paragraph 2 will reveal the prayer.
Let a notice be served upon
No, that would be better.
Yes.
Because his presence
Since
is necessary.
no affidavit has been filed by the
His state's affidavit is
high
more material.
Right. The writ petition is taken up for consideration, wherein the petitioners has prayed for regularization of the service as accounts and finance coordinator, urban planner and information technology coordinator in group A. Stop. Municipalities are represented by next paragraph. Municipalities are represented by learned advocates today. However, no one is representing the state respondents. Next paragraph. Considering the grievance of the petitioners, this grievance of the petitioners, representation on behalf of the state authorities, especially director of local bodies, is needed. Next paragraph. The learned advocate for the petitioners is directed to serve notice upon the learned advocate representing the state respondents, enclosing the order of this court by 4th March 2024. List the matter under the same heading for further consideration on 7th March 2024. Serve notice and
next week.
Definitely, when the learned advocate will come, he will pray for time to file everything. Extension of time.
Lordship is posting it on the supplementary list because 7th
Yes.
Lordship is yes. Supplementary.
Yes.
Great.
Item number 170.
Time for the corporation.
At the time of call, no one appears for the petitioner. At the time of call, no one appears for the petitioner and no accommodation is prayed for. However, Bidhannagar Municipal Corporation is represented by learned advocate. Next paragraph. List the matter under the heading Motion Group 5 Municipality for disposal on.
Millard has kept the last matter on 11th of March.
On 11th March 2024. Next paragraph. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. Next.
Item number 171.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Next paragraph. List the matter under the heading Motion Group 5 Municipality for disposal on 11th March 2024. Next paragraph. However, it is made clear if on the urgent date petitioner goes unrepresented, consequential order shall be passed. If
Ask you.